Imagine a world where 29 complex, fragmented, and often archaic laws are harmonized into just 4 powerful pillars of governance. Imagine a shift so monumental that it transforms the very DNA of the Indian workplace, moving us from a legacy of rigid control to a future of digital empowerment and mutual prosperity. On November 21, 2025, this vision became our reality. We are no longer standing on the precipice of change. We are walking through the doors of the great transformation. The question is not whether you are aware of these changes, but whether you are truly ready to harness the power of this new industrial era. Welcome to a definitive exploration of India's new labor code framework. Today we are not just discussing laws, we are decoding the blueprint of the modern Indian economy. This is a narrative of simplification, security, and sustainable growth, the 3S philosophy that now governs every office, factory, and gig platform across the nation. For decades, employers and employees alike navigated a maze of litigation and paperwork. Today, that maze has been replaced by a streamlined digital-first ecosystem designed to enhance the ease of doing business while simultaneously expanding the safety net for millions of workers. This transformation is built upon 4 specific pillars: the Code on Wages 2019, the Code on Social Security 2020, the Industrial Relations Code 2020, and the Occupational Safety, Health and Working Conditions Code 2020. These are not merely regulatory updates. They are a structural reset of the labor market. We've moved away from the Inspector Raj of the past to the era of the Inspector-cum-Facilitator. The focus has shifted from finding faults to ensuring compliance through web-based inspections and transparent governance. Whether you are managing a workforce or building a career, understanding these nuances is no longer optional, it is the currency of your professional success. Let us begin by dissecting the financial backbone of this reform, the Code on Wages 2019. The most critical and financially impactful change lies in the new unified definition of wages. In the past, compensation structures were often designed with low basic pay and high allowances to minimize social security contributions. That era is effectively over. The new code introduces a mathematical mandate that demands our full attention: the 50% cap on exclusions. To understand this, we must look at the formula. Under the new code, wages includes basic pay, dearness allowance, and retaining allowance. However, it specifically excludes components like house rent allowance, conveyance, overtime, and house accommodation benefits. Here's the critical catch. If the aggregate of these excluded components exceeds 50% of the total remuneration paid to an employee, the excess amount is legally added back into the wages for the calculation of benefits like Provident Fund and gratuity. Let us visualize this with a calculation. Suppose an employee has a total monthly remuneration of 1 lakh rupees. If the basic pay and dearness allowance amount to 40,000 rupees and the allowances amount to 60,000 rupees, the allowances constitute 60% of the total. Under the new rule, allowances cannot exceed 50%, which would be 50,000 rupees. The excess 10,000 rupees is strictly deemed as wages. Therefore, the Provident Fund contribution will not be calculated on 40,000 but on 50,000. This structural change ensures higher retirement savings for employees and demands a recalibration of cost-to-company models for employers. Moving beyond the definition of wages, the code brings a revolutionary change to the full and final settlement timeline. The days of waiting weeks or months for exit dues are behind us. The Code on Wages mandates that in cases of resignation, dismissal, or removal, all wages payable to an employee must be settled within 2 working days of their last day of work. This provision alone requires a complete re-engineering of exit processes, ensuring that clearance certificates and finance approvals are digital and instantaneous. Alongside wages, we see the implementation of the Code on Social Security 2020. This is perhaps the most humane and forward-looking aspect of the reforms. For the first time, the legal framework explicitly recognizes and protects the gig and platform worker. The economy has evolved and the law has finally caught up. A dedicated social security fund is now established, funded by contributions from aggregators ranging from 1 to 2% of their annual turnover. This ensures that the delivery partner or the freelance consultant is no longer invisible to the state but is a secured beneficiary of health and maternity benefits. Regarding gratuity, the changes are equally significant for the modern and mobile workforce. Previously, a continuous service of 5 years was the golden key to unlock gratuity. The new code democratizes this for fixed-term employees. If an employee is hired on a fixed-term contract, even if it is for 1, 2, or 3 years, they are entitled to gratuity on a pro-rata basis. They do not need to wait for 5 years. This encourages the formalization of contract labor while giving employers the flexibility to hire for specific projects while ensuring that the employee is not financially penalized for the temporary nature of the role. Let us now turn our attention to the Industrial Relations Code 2020. This code attempts to strike a delicate balance between the rights of the workers and the operational fluidity required by industries. One of the most discussed changes is the raising of the threshold for standing orders. Previously, establishments with 100 or more workers had to formally certify their standing orders, the rules of conduct and discipline. This threshold has been raised to 300 workers. This change significantly reduces the compliance burden for medium-sized enterprises, allowing them to define their internal policies with greater autonomy, provided they adhere to the model standing orders. However, with greater flexibility comes greater responsibility regarding dispute resolution. The concept of strike has been redefined to prevent sudden disruptions. The new regulations mandate that no person employed in an industrial establishment shall go on strike without giving a notice of change within 60 days before striking, and certainly not within 14 days of giving such notice. This 14-day cooling off period, which previously applied largely to public utility services, is now a universal mandate. It forces dialogue before disruption, ensuring that arbitration and conciliation are the first lines of defense, not the last. Further, the Industrial Relations Code institutionalizes fixed-term employment. Employers can now hire workers for a specific duration without the intervention of a contractor. These employees are entitled to the same hours of work, wages, allowances, and statutory benefits as permanent workers doing the same work. This eliminates the exploitation often seen in indirect hiring and provides a dignified, transparent avenue for employment that suits both seasonal industries and skilled professionals seeking project-based roles. The fourth pillar is the Occupational Safety, Health and Working Conditions Code 2020. Commonly known as the OSH code. This is where the physical reality of the workplace meets the law. The most empowering change here is the universal provision for women to work in any establishment at any time, including the night shift from 7 p.m. to 6 a.m., subject to their consent and the employer's provision of adequate safety, working hours and holidays. This is a massive step towards gender equality in the workforce, particularly for the manufacturing and logistics sectors, opening up 24/7 operations to the entire talent pool. Safety protocols have also been tightened with stricter timelines. In the unfortunate event of a fatal accident or one causing serious bodily injury, the employer is now legally bound to send a notice to the inspector-cum-facilitator within 4 hours electronically or 12 hours physically. This tight window eliminates the possibility of data manipulation and ensures immediate state intervention and inquiry. It compels organizations to have pre-drafted templates and rapid response teams ready, moving safety from a passive manual check to an active real-time priority. From a licensing perspective, the OSH code introduces the concept of a single license. Contractors who work across multiple states previously struggled with a multiplicity of licenses. Now, a single pan-India license replaces this fragmentation, valid for 5 years. This is a triumph of the one nation, one license ethos, drastically cutting down the administrative overhead for businesses that power India's infrastructure and services. Compliance under these new codes is no longer about maintaining dusty registers stacked in a storeroom. The regime mandates the electronic maintenance of registers and records. The filing of returns has been consolidated, often into a single annual return. The logic is clear. Transparency through technology. The inspector-cum-facilitator will not just visit at random. Inspections are now determined by a web-based, randomized selection scheme. This reduces harassment and corruption, ensuring that inspections are data-driven and focused on genuine high-risk areas. However, do not mistake this facilitation for leniency. The penalties for non-compliance have been revised and in many cases substantially increased to act as a genuine deterrent. While the codes decriminalize minor procedural lapses, focusing instead on financial penalties, they are severe on repeat offenders. For instance, a second conviction for obstructing an inspector or failing to comply with key provisions can lead to imprisonment and hefty fines. The system offers a compounding of offenses mechanism for first-time errors, allowing businesses to pay a penalty and correct their course without enduring a long criminal trial. This saves the court's time and allows businesses to remain operational provided they rectify their non-compliance immediately. Let us discuss the crucial aspect of vacancy reporting, a mandate under Chapter 12 of the Social Security Code that often flies under the radar. Employers in every establishment are now required to report vacancies to career centers electronically before filling the post. This applies to all establishments excluding agriculture and domestic service. This is not just a bureaucratic step. It is designed to link the National Career Service Portal with active recruitment, creating a data-rich labor market where supply meets demand efficiently. The calculation of monthly contributions and the management of leave have also seen standardization. Under the OSH code, the eligibility for leave encashment and the quantum of leave allowed to be carried forward has been streamlined. Overtime itself requires the express consent of the worker. It cannot be forced. The rate of wages for overtime remains at twice the ordinary rate of wages, a non-negotiable standard that protects the employee's time and effort. We must also touch upon the state rule mapping. While these are central codes, labor is a subject on the concurrent list of the Indian Constitution. This means state governments have the authority to frame their own rules for the implementation of these codes. As a deep researcher into this transition, it is vital to note that while the central framework provides the skeleton, the flesh and blood, the specific forms, the local authorities, the appellate bodies are defined by state rules. A compliant organization today must have a dynamic compliance matrix that tracks notifications from every state capital where they operate. The action plan for any organization navigating this landscape involves a transition from manual dependencies to HRIS, that is Human Resource Information Systems. The formulas we discussed, the 50% wage cap, the pro rata gratuity, the overtime calculations, must be embedded into the payroll software. Manual calculation is not just inefficient, it is a liability. The system must automatically flag if a salary structure violates the wage definition or if a full and final settlement is pending beyond the 48-hour window. This brings us to the core of why this matters. The great transformation is not merely about adhering to sections and subsections, it is about the philosophy of the workplace. The new labor codes acknowledge that a secure worker is a productive worker. By mandating appointment letters for every employee, ensuring diverse and safe working hours for women, and securing the future of gig workers, the state is investing in the quality of its human capital. For the employer, the removal of archaic restrictions and the digitization of compliance lowers the barrier to entry and expansion. We are witnessing the maturity of the Indian industrial ecosystem. The relationship between the employer and the employee is being redefined from one of conflict to one of cooperation. The industrial relations codes focus on grievance redressal committees for establishments with 20 or more workers is a testament to this. It mandates an internal mechanism to solve disputes before they escalate, fostering a culture of dialogue and internal resolution. As we analyze the compliance report and the detailed action plans associated with this transition, one theme resonates: proactivity. The organizations that wait for a notice to change are the ones that will face financial shocks. The organizations that proactively restructure their compensation benefits, who audit their contractors' compliance, and who digitize their safety reporting are the ones that will thrive. The financial implications of the wages definition will likely increase the employer's contribution to the provident fund, thereby increasing the overall staff cost. However, this is a trade-off for the clarity and flexibility gained in hiring fixed-term employees and the ease of a single license. It is a move towards a formal, transparent economy where under-the-table deals are replaced by on-the-record rights. In conclusion, the message of the new labor codes is powerful and clear. We have moved from a fragmented past to a unified future. November 21, 2025 marks the beginning of an era where compliance is a badge of honor, not a burden. It is an era where the law facilitates business growth while zealously guarding the dignity of the worker. This journey of compliance is continuous. It requires vigilance, adaptation, and a commitment to the spirit of the law, not just the letter. As we embrace these changes, we are building a workforce that is secure, an industry that is agile, and a nation that is economically robust.